All right, well, welcome everybody to the special lecture, which is funded by the Association for Korean Studies in Europe for week 10 of our class, Politics of Everyday Life in Modern Korea at the University of Edinburgh. I am very pleased to introduce our speaker today, Dr. Justine Guichard, who is Associate Professor of Korean Studies at Université de Paris, and she has had previous affiliations at George Washington University, the University of Pennsylvania, Sciences Po, and Columbia University, where she gained her PhD in political science. Dr. Guichard is an interdisciplinary political scientist who specializes in the study of contemporary Korea in a comparative and transnational perspective. And she has research interests in justice, violence, memory, and identity within and beyond the peninsula. And she has authored several journal articles on these topics. I encourage you to check them out. There's information on the class website, as well as a monograph publication, Regime Transition and the Judicial Politics of Enmity, Democratic Inclusion and Exclusion in South Korean Constitutional Justice, which was published in 2016 through Palgrave Macmillan Press. And this is exactly why we have invited Dr. Guichard to speak with us today, because of her expertise in these questions of democracy and law, not just from a technical or a legal perspective, but with a very real interest in the human implications of the ways that law is applied and utilized in South Korea. So without further ado, I welcome Dr. Guichard today, and we look forward to hearing what you have to say to us.
Thank you, Dr. Stevens, for the introduction and for the invitation. I am really pleased to be with you today to talk about South Korean society's struggle for legal change since 1987. So I hope you all see the diaporama that I'm now projecting. So, as you know, as I believe you've studied, the year 1987 is considered as a turning point for South Korea. It is indeed the year when the country transitioned from authoritarianism to democracy, and South Korea in 1987 underwent that transition as a result of a social movement. That is to say, as a result of society's mobilization to make change happen, as a result of mass protests. So we can say that in 1987, the pressure for change, it largely came from below, right, from South Korean society itself. But the process of change in turn, it largely came from above. That is to say, the process of change was largely controlled by political elites from the ruling and the opposition parties. So the process of change in 1987, the process of the transition from authoritarianism to democracy, it mostly took the form of a revision of the constitution. A revision of the ROK Constitution, the Republic of Korea's constitution. That's, in a sense, the main legal change that happened in 1987. So the ROK Constitution, maybe just to give you a little background, it's a document, it's a text that was first adopted in 1948, when the Republic of Korea, so the South Korean state, was founded, was created, and that constitution has since 1948 remained in place, but it has been modified, it has been, to put it differently, it has been revised, it has been amended several times since 1948. To be more precise, it has been amended 9 times. And so the revision that took place in 1987 was the last and the 9th revision of the South Korean constitution, the ROK Constitution. So again, this revision of the constitution that took place in 1987, it was the main legal change, we could say, that was adopted that year. And in a sense, it was a major change. It was a major change to amend, to modify the constitution. For instance, that constitutional revision, it did bring about significant transformations for ordinary citizens, and in particular, the constitutional revision, it did restore the ability of South Korean citizens to directly vote for the president. So direct universal suffrage was reintroduced in 1987 with the revision of the constitution. So in a sense, it was a major legal change, but at the same time, it also represented a limited kind of change. Why? Because South Korean authoritarian regimes, South Korean successive authoritarian regimes since 1948, they did not only rest on the constitution, of course. Authoritarianism in South Korea also rested on a broader legal apparatus, right? On a vast array of laws and a vast array of regulations. And most of those laws and regulations, they were not immediately changed in 1987. They were not automatically changed in 1987. So in a sense, we can say that 1987, it represents not the end, but rather it coincides with the beginning of South Korean society's struggle for legal change. In other words, for South Korean society's struggle for undoing a large variety of laws that were perceived as unjust and as unfair. And as we will see, many areas and many issues have been concerned. So that's really the first point upon which I would like to insist today, that South Korean society's struggle for legal change started rather than ended in 1987. The second point I would like to make today is that in this struggle for legal change, ordinary citizens have been able to avail themselves of a new tool, of a new instrument after 1987. And that new tool, that new instrument, that has been the Constitutional Court of Korea. The Constitutional Court of Korea, as we will see in more detail, it's an institution that was precisely introduced during the 1987 revision of the Constitution. So it's a new institution that began to operate after 1987. And more importantly, it's an institution, as we will see, to which ordinary citizens have been able to directly appeal. An institution to which ordinary citizens have been able to individually appeal. So here is the outline of the lecture, the outline we will follow today. So first, we will see how ordinary citizens have been empowered by constitutional justice, by those new mechanisms that were introduced, that were created in 1987. So how ordinary citizens have been empowered by constitutional justice to challenge the state and to press their rights for the past 3 decades. Then we will evoke what issues they have mobilized around, and we will see that there's been a variety of issues and that they have, of course, expanded over time. And lastly, but more so by way of conclusion, we will consider to which extent has South Korean society been successful in challenging the state through legal channels. So first, let's try to understand how ordinary citizens have been empowered after 1987. And to understand this empowerment, we need to go back to the 1987 revision of the Constitution that I was previously talking about. So among the modifications that were introduced in the Constitution in 1987, among those modifications, an important one was the introduction of this new institution called the Constitutional Court of Korea. So the Constitutional Court of Korea, it was introduced in the 1987 Constitution. It was more precisely introduced in Chapter 6 of the Constitution, and more specifically in Article 111 that you can read here. Alors first, I would like us to consider, as you can see, Article 111. It's composed of different sections, right? So first, the first section is dedicated to the powers of the Constitutional Court. Of course, we're going to talk about that because that's important. But I would like us to first consider the other sections that deal with the composition of the Constitutional Court to understand who's part of that new institution. Alors, as you can see, as you can read, the Constitutional Court, it's an institution that's composed of 9 justices who are all professional judges and who are all appointed by the president, by the South Korean president. So if you read the following section, all the justices are appointed by the South Korean president, but actually their mode of selection, is divided among the 3 branches of government. And the 3 branches of government, they are the executive, the legislative, and the judiciary branches. So in fact, the president, the head of the executive, he has the power to formally nominate, to formally appoint the 9 justices, but he or she actually, again, the South Korean president has also been a female, we will see that too. The president, he or she, only gets to choose 3 justices. Right? The president only chooses 3 of the 9 justices that he or she appoints. The other justices, 3 of them, as you can see, 3 of them are selected by the National Assembly, so the legislature, the legislative branch. In South Korea, the parliament, the legislature is unicameral. It's only made of 1 chamber, so there's only a National Assembly that gets to choose 3 justices, and another 3rd, so the rest of the 9, another 3, are chosen by the Chief Justice of the Supreme Court, the head of the Supreme Court, that is to say, by the judiciary branch. The Constitutional Court itself, it is outside the judiciary system. It is outside the judiciary branch. And so there is an important distinction in South Korea between 2 courts, one being the Supreme Court and the other being the Constitutional Court. So maybe to say things a bit simply, the Supreme Court, it's the court of last appeal. It's the court that rules after lower courts, after appellate courts. The Supreme Court, it's the highest institution of the judiciary. But as I said before, another court exists alongside, and that's the Constitutional Court, which is outside the judiciary and which is in charge of its own matters, of specific matters, and in particular of constitutional matters. So we're going to see now actually which matters does the Constitutional Court deal with. So as you can read, first, the Constitutional Court, it reviews, it is in charge of reviewing the constitutionality of a law upon the request of the courts. That means that the Constitutional Court, it decides whether a law is compatible or not with the Constitution upon certain conditions. And so the explicit condition that is formulated here is that there must be a request, right? There must be a request to examine a law, to examine the constitutionality of a law. And this request must come from the ordinary courts. So the lower courts, the appellate courts, even possibly the Supreme Courts, the courts of the judiciary. So implicitly, that means that there must be a trial. There must be a trial, or there must be a lawsuit going on for a court to request a review of the constitutionality of a law. And this, if that was the only power of the Constitutional Court, this would be very constraining for ordinary citizens. This mechanism, it puts a double constraint, if you will, on ordinary citizens. First, ordinary citizens need to be involved in a lawsuit or in a trial, and then they need to obtain, in a sense, the agreement of a court to request that a law be examined. So this mechanism is in a sense quite restrictive, but we will see that precisely in 1987, another mechanism, if you want, another mechanism was introduced for ordinary citizens to appeal to the Constitutional Court, because this one is not so easy to use. So briefly to go over the other powers of the Constitutional Court. The Constitutional Court is also in charge of adjudicating impeachment. That is to say that it has the power to impeach high public officials when they violate the law, when they violate the Constitution. And the Constitutional Court has exercised this power, in particular, most recently in 2017, when it confirmed the impeachment of South Korean President Park Geun-hye. The Constitutional Court, it also has the power to dissolve political parties, and to dissolve political parties when their aims or their activities are contrary to the Constitution. It is also in charge of settling competence disputes between a variety of agencies and different levels of government. And finally, and this is really what's going to matter to us, it's really what's important here. As you can see, the Constitutional Court is in charge of adjudicating constitutional complaints. Constitutional complaints as prescribed by Act. So this last point, the introduction of constitutional complaints, that was the real innovation. That's a real innovation that has empowered ordinary citizens to challenge the state since 1987. As we will see, constitutional complaints, they represent a very open mechanism to appeal to the Constitutional Court, as opposed to this first mechanism we talked about, which is quite a narrow mechanism. Constitutional complaints, by contrast, they represent a very open mechanism that was not defined in the Constitution of 1987. As you can see, constitutional complaints were mentioned, but they were not exactly defined. There was no agreement made, no decision made about how they would exactly work in practice. So constitutional complaints have been, their working has been then specified explained by act, by law, with the adoption of the Constitutional Court Act in 1988. And as you can see, the Constitutional Court Act of 1988, it states that any person, right, any person whose basic rights guaranteed by the Constitution are infringed upon, so any person whose basic rights are infringed upon by an exercise or non-exercise of public authority, excluding the judgments of ordinary courts, may file a constitutional complaint with the Constitutional Court. Now, this article may seem a little perhaps difficult to understand at first, but basically what it means is that it gives to any person, any individual, right, who considers that his or her basic rights are being violated, it gives so to any individual the power to directly appeal to the Constitutional Court and to do so by filing a constitutional complaint. So here you don't need to be in the scope, in the frame of a trial, in the frame of a lawsuit, right? Anyone basically can file a constitutional complaint as long as this person considers that his or her basic rights are being infringed upon, are being violated upon, by what? By an exercise or non-exercise of public authority. So this notion, as you can see, in 1987, it's a rather large notion that, again, was not defined in the Act. And it has been left to the Constitutional Court itself, in its rulings, in its jurisprudence, to define what this means, an exercise or non-exercise of public authority. So the Constitutional Court, it has addressed this question early on. It has specified what it means, and over time it has also expanded it. And basically, the Constitutional Court considers that public authority, the public authority mentioned here, it encompasses both legislative authority and executive authority. Otherwise, or to put it differently, ordinary citizens can challenge legislative authorities. That is to say, they can challenge the laws, right? Laws that they consider are infringing upon their basic rights. That's basically what legislative authority is. The fact that every citizen has the power to challenge a law, to challenge the constitutionality of a law, if she or he considers that the law is violating his or her basic rights. And on top of that, ordinary citizens can also challenge executive authority when they consider that executive authority infringes upon their basic right. And executive authority here, it can mean executive orders, it can mean administrative regulations, it can mean ordinances. To give you an idea, there's been a constitutional complaint filed, for example, against the decision of the South Korean president to send troops to Iraq. You see, because constitutional complaints are such an open mechanism that basically any exercise or non-exercise of public authority can be challenged through them. Then it doesn't mean that the case is successful, but it means that society can be very active through this mechanism of constitutional complaints. The one thing that cannot be challenged is the judgments of ordinary courts, the rulings that ordinary courts make. You cannot challenge them saying that they are unconstitutional. But it's possible, if you remember, it's possible to file a constitutional complaint when courts refuse to request that the constitutionality of a law be examined. If you remember, that was the first mechanism we evoked, right? That ordinary courts can request that a law be examined, that its constitutionality be examined. And when they don't want to request it, right, when they don't want to request it, ordinary citizens can actually file a constitutional complaints and so directly go to the constitutional court, bypass, if you will, the ordinary courts. So most cases, really most cases that have reached the Constitutional Court since 1988, the Constitutional Court, it opened its doors in 1988, and most of the cases it has received since are constitutional complaints. As you can see, the court, it has received 42,000 cases in total between 1988 and today, and 40,000 of those cases are constitutional complaints. That is to say, more than 95% of the cases that the Constitutional Court receive are constitutional complaints. And those complaints, it's complaints that have been filed by ordinary citizens, by individuals, oftentimes, though, with the help of associations, that militate for legal change, and for example, an association that has been active in the late 1980s in militating for legal change was a lawyers associations, Lawyers for a Democratic Society, Minbyon in Korean, and it's often so individuals, of course, or ordinary citizens that have appealed to the Constitutional Court, but with the help, oftentimes, of associations. So now we'll see what ordinary citizens have fought for after having discussed how they have been empowered to challenge the state and to press the rights through this mechanism of constitutional complaints. Let's see what they have fought for. And here there are a variety of issues, as you can see, that have been, so this is only a selection of the issues that ordinary citizens have mobilized around. So among the first set of issues have been criminal rights, fighting for greater criminal rights protections, fighting also for the freedom of expression. Those were issues that were particularly strong, predominant in the late 1980s and throughout the 1990s. And over time, of course, the range of issues has expanded, and we will see more recent examples. And among them has been the fight for greater equality, and in particular, the fight against discrimination, the fight against gender discrimination, the fight against religious discrimination, and the fight for sexual freedom. And we'll see that some of the most recent cases decided by the Constitutional Court deal with the issue of individuals' right to sexual determination, self-determination. So if Dr. Stephen, don't hesitate to interrupt me if I take too long, but if we have time, I'd like to show a few examples of each of those issues.
That would be great, thank you.
So let's start with criminal rights. And so in 1991, for example, the Constitutional Court was asked whether suspects can freely communicate with their attorneys, can privately communicate with their attorneys, even in national security cases. So in 1991, here is 1992 is the year of the decision, but the case it was brought the year before in 1991. there was a case of a suspect who was arrested for violating the National Security Act, and whose communications, as you can see, with his lawyer, with his counsel, were constantly monitored by secret services. And so that person, the suspect, filed a constitutional complaint before the Constitutional Court. And in 1992, the Constitutional Court ruled that indeed restricting the right of suspects to freely communicate with their attorneys, even in national security cases, as the court ruled that restriction was unconstitutional, and that the right of suspects had to be guaranteed, had to be protected, even in national security cases. So there's been a lot of issues revolving around criminal rights. We're not going to talk about them all, but I wanted to mention a more recent decision, although it's already a bit old, but to show you how constitutional complaints are an open mechanism that empowers ordinary citizens to challenge not only laws, right, but also a lot of decisions, a lot of regulations adopted by the state. So the decision was rendered in 2001, but the case started here again a year before, in 2000. And the Constitutional Court was asked in 2000 whether open lavatories, as you can see depicted on the image, whether open lavatories in police detention facilities infringed or not on individual basic rights. So the case here again, it came from someone who was arrested and who was detained in a police station, had to share his cell, a cell in which, as you can see, there was a toilet, but an open toilet that didn't afford any privacy. And so that person considers that this was an infringement of his basic rights by an exercise of public authority, by an exercise of state power. And that person was therefore able to directly file a constitutional complaint before the Constitutional Court. And the court in 2001 recognized that, that insufficient cover or open lavatories in police detention facilities was against human dignity and therefore was unconstitutional. So here is another example related to the realm of criminal law, but more so about the freedom of expression. In 1990, the Constitutional Court reviewed Article 7 of the National Security Act, which the National Security Act is basically a law that has been enforced in South Korea since South Korea was created, and it's a law that has particularly been used against political opponents during the authoritarian regime. It's a law that has particularly criminalized political opponents as enemies. And the challenge was brought against the National Security Act, and in particular against Article 7 of the National Security Act that criminalizes, that punishes the fact of praising an anti-government or an anti-state organization. An anti-government or an anti-state organization, it's a formula that's used in the law basically to refer to North Korea. So under the National Security Act, of course, it's illegal to aid North Korea. It's illegal to perform a range of activities that could benefit North Korea, but it's even illegal to praise North Korea. And so the constitutionality of this article early on has been challenged before the Constitutional Court. And the Constitutional Court here didn't rule that the National Security Act and that Article 7 were unconstitutional, it ruled that they were only conditionally constitutional. That is to say that the provision is compatible with the Constitution, provided that it is interpreted and provided that it is applied narrowly. So this was a sort of not full victory, right, in this case. And there have been many challenges against the National Security Act since, and in all those cases, the Constitutional Court has maintained this position, which is that the National Security Act is constitutional as long as it is interpreted and as long as it is applied in a narrow way, that is to say, not to punish in particular dissent. And that has been relatively controversial. Decisions relating to equality. I was telling you from the 2000s onwards, there have been ordinary citizens have fought for greater variety of issues, including equality. They have fought for undoing discrimination, and in particular, gender discrimination. And that has been the case in the early 2000s. In the early 2000s, women have filed petitions, have filed complaints before the Constitutional Court to challenge what was called the head of household system. So under the current, the legal system at the time, under the civil code, only men could be recognized as head of the household, and that has been challenged. So in the early 2000s by women filing a constitutional complaint, and the Constitutional Court has indeed recognized that this constituted a discrimination against women, and that as a result, it was not conform to the Constitution. A more recent example, as you can see, 2018, a more recent example of discrimination against which ordinary citizens have fought is religious discrimination, in particular in the context of South Korea's military service, which is mandatory, right? Where every male have to perform the military service without exception. So the system did not recognize the possibility of conscientious objection, right, of not performing the military service, in particular for religious reasons. And here again, very recently, in 2018, the Constitutional Court has considered that prohibiting conscientious objection to the military service was not conform to the Constitution. And the court has said that an alternative to the military service must be provided, must be offered to those who object to the military service for religious reasons. Here, I would like to highlight the fact that 2018, it's very recent, and that actually over the years, there have been multiple and repeated challenges against the military service. So over the years, there have been, since the 1990s, challenges against the military service, but it's only 2018 that the Constitutional Court recognized that the prohibition was problematic. And this pattern, it's the same when it comes to sexual freedom. So in 2015, as you can see, the Constitutional Court ruled that criminalizing adultery was unconstitutional. That is to say that punishing a sexual relationship between a married person and someone else and the spouse was contrary to the Constitution. So here again, it's a decision that intervened rather recently, and more so that was made after many challenges, repeat challenges were brought to the Constitutional Court over the years. And this has also been the case of abortion, which has been one of the most recent decisions by the Constitutional Court, and the last one that I will talk about today. In 2019, the court recognized that the criminalization of abortion was not conform to the Constitution. That is to say that it was against the Constitution to punish women who terminate their pregnancies, and that it was also against the Constitution to punish the medical personnel who helps them. And here again, 2019, so this decision is very recent, and it was made after 4 years, for decades, women have mobilized to file constitutional complaints. So I would like to conclude precisely on this image. As you can see, the previous images that I've used, they all come from the Constitutional Court website. So if you go to the Constitutional Court English website, there is a section where that's called Decisions in Cartoons. So it offers an English summary of several landmark rulings of the Constitutional Court, and that's where I borrowed those pictures, except this one. And so I would like to conclude upon that picture, which doesn't come from the Constitutional Court, and which illustrates, I believe, the fact that, yes, the Constitutional Court has been a very active institution since South Korean democratization, but it has been active due to the fact that South Korean society itself has been active, that ordinary citizens have been active in bringing challenges against the states. And they have done so not just once, but really repeatedly. So legal change has been obtained, has been possible and has been obtained, but oftentimes only after repeat challenges, only after multiple challenges. So legal change has happened, but I would say that it has been rather slow and incremental, and more importantly, that it has been the result of continued mobilization on the part of South Korean society, on the part of ordinary citizens. So since 1987, we can say that the law in South Korea is no longer just an instrument of power. Since 1987, the law, it has been a double-edged tool, right? Both something to fight against, as we've seen, but also something to fight with. So perhaps I will stop there and take your questions if you have any.
Thank you very much, Justine. That was wonderful.